Good evening, this is John Milburn for LAWS11057, Introduction to Law, and this is week 11 of Term 3, 2018. Next week we have our paper, our take-home paper, and this evening we're following on from our discussions from last week, starting first with the topic of dealing with disputes, providing advice generally to clients, and doing so within an ethical context. When I went through university and at the very start of my career, talking the 70s and early 80s, the primary emphasis was on litigation. If you had a dispute, then immediately you think in terms of what is the litigation option. Now that has changed considerably since those decades. So now we, for want of a better term, need to look at things in a much more holistic way. So I'm going to invite you to get your thinking caps on, and I do thank you for joining me on a public holiday. Those of you watching this as a recorded session, please give some thought to the questions that I'm about to ask. I'm going to ask if you could tell me what you believe some of the appropriate alternatives are to litigation when advising clients in relation to a dispute. Fire away using the chat facility. Mediation, says Tanya. Thank you very much. Any others? So we have mediation. Any other options that might be available to a client to at least consider in the event of a dispute? Those of you watching a recorded session, pause, think about it, see if you can come up with some others. All right, well, at the moment, we're stuck on mediation. What about this? What about acknowledging that the amount of money involved is substantial, or the issues of concern are of considerable importance, but also acknowledge that there's a cost, financial, emotional, and recommend to the client that they at least consider walking away from the dispute and taking no action. Now, that was certainly something that wasn't taught to me at an early stage, but I think in some circumstances, it's appropriate to at least consider walking away from the dispute. Another option might be to make a direct approach. Sometimes it's better to resolve issues face to face. Try to sort things out over a cup of tea or perhaps a beer. Again, that's not something that lawyers are traditionally trained to encourage people to consider. Taking that one step further on, we have mediation. And Tanya suggested that. Thank you very much for doing so. So a mediator guides the process, goes through a process of intake, and does not sit as a judge or a jury, if you like. Mediation is typically a voluntary service, although you'll learn as part of your civil procedures that there are circumstances which compel parties to attend a mediation session. And mediation is different to conciliation, but they are some of the formalised ADR methodologies available. In laws for this university, I think it's 12062, alternative dispute resolution, we go through a process of discussing at least 14 different formal types of ADR. Mediation is one of those. Apart from that, what other generalised ways are there of resolving a dispute? Well, what about encouraging parties to make a complaint? Now, it might be the Office of Fair Trading, the Australian Competition and Consumer Commission, it might be members of Parliament, or it might be an ombudsman. Can anyone tell me, can you think of any ombudsman services that might be available, depending on the nature of the dispute, of course? Again, just trying to write, here we go, thank you very much. Gareth says telecommunications, and acknowledges that there's a cost to benefit analysis required here. I totally agree with that. Thank you. Any other ombudsman services that come to mind? Energy, financial services, telecommunication, government ombudsmans dealing with disputes between public and government. So these are valuable resources. So I'd encourage you to do some research to find the appropriate website for some of the Ombudsman services that might be available. Otherwise, maybe a proper complaint is to the police, depending on the nature of the dispute. If you're dealing with a circumstance where you're trying to take action to protect the rights of someone who is disadvantaged, for example, lacking capacity as an adult, then the Office of the Public Guardian may be an alternative to litigation. Or if you do go to litigation, it may be appropriate to bring that litigation in QCAT, dealing with guardianship and administration issues. There may be other tribunals that you might consider, or commissions, the Anti-Discrimination Commission, Superannuation Complaints Tribunal. These are all different options. Telecommunications Ombudsman, yes. Then sometimes you need to advise your client before proceeding further to undertake some further research or inquiry. So that might be doing some searches, possibly even some investigation. And when you're giving advice to clients, be prepared to think laterally in terms of the potential liability of third parties. Maybe there's someone with an insurance company with, as we call it, deep pockets, sitting behind the person that you're chasing. So there are different options that might be available. As a last resort, although clients sometimes see it as a first resort, going to the media might assist. So these are all part of the brainstorming techniques that you might want to consider in terms of providing preliminary advice to a client. And it's the sort of thing that we do in a mediation session quite often as well, as a way of trying to resolve a dispute. Now, as part of your introduction to law course unit, you should have some reasonable idea now of the various options available to clients involved in a dispute situation. You should have some idea of the monetary limits of different courts and tribunals. You should have a good idea of the distinction between state litigation and Commonwealth-based litigation. And you should then consider different alternatives to litigation completely. So do you think that we're at that stage? And if you're watching this as a recorded session, critically ask yourself that question. Now I'm going to give you a quick quiz just to test where you're at. So number one, just tell me which is the appropriate court or tribunal if a client wishes to pursue a debt of $5,000. There may be more than one. QCAT was the popular choice. All right, what about the Magistrates Court? Can you pursue a $5,000 debt? Tanya says Magistrates Court. Yes. Can QCAT deal with every dispute up to $5,000? Or are there other issues? The answer is there are other issues that might be involved. All right, what if your dispute is $50,000? Just where do you think the appropriate court or tribunal might be in those circumstances? So we're getting votes for magistrates. All right, magistrates. What if you're dealing with a federal issue? Would you go to the state magistrates court? The answer is you can because of cross-vesting jurisdiction, but the federal court or the federal circuit court might be appropriate. What if you're pursuing $50,000 dispute involving a dispute between married couples? Maybe you go to the federal circuit court, or the family court now. What if you're dealing with a $500,000 dispute between a customer and the builder in relation to a domestic building contract? Where would you go for that dispute? Gareth's right, trick question, QCAT. Even though it's $500,000, it's the type of dispute that QCAT has jurisdiction in relation to. So these are all the sorts of things that you need to consider, and please be on top of that. All right. Also, you need to understand the distinction between that which is equitable and that which is what we call legal or at common law. Now, of course, equitable decisions do form part of our common law. That's where it becomes a bit confusing. But bear in mind that some remedies that you seek are what we call equitable remedies, and not every court or tribunal has power to grant the remedy that you seek. All right. Now, the particular thing that I said for you for this week was to do with ethics. Have we all had a chance to look at the Australian Solicitors Conduct Rules, the Barristers Rule, and the Queensland Law Society Ethics Centre? Was that a yes? Very good. All right. Thank you very much. One thing that you will note on the Queensland Law Society site is some valuable resources and some quotes. And there's one that I selected that I quite like. It was a little while ago on the site. It needs to be emphasised that the efficient conduct of commercial litigation, indeed all litigation, can only be assisted by restraint, moderation, sensible cooperation and sound judgment. Indeed, the due administration of justice demands it. This is part of the wider duty to the court, and that's the decision of McLaughlin against Dungowan, Manly, Pty Ltd, 2011 NSWSC 717. McLaughlin against Dungowan, Manly. And if you want to see that quote, it's at paragraph 30. As a general tip, again, information that I've taken from the Ethics Centre, retired Major General John Cantwell said that with respect to leadership, good leaders take time for reflection. When concerned by an ethical dilemma or problem, taking time to reflect and think ahead is important. So when it comes to ethics issues, do take time and be prepared to ask questions, but do so after you've considered the basic material. In other words, when I was a partner in a law firm, people would come to me, say, in conveyancing matters and ask a question. And unless I was satisfied they'd done their own research, I might send them back to say, for example, have you checked the contract in relation to that issue? So the same thing applies for an ethical dispute. By all means, ask questions, seek advice, but do your preliminary research first and form a basic opinion. All right, let's try to share the screen now. And if you have any questions as we go, please ask, and we'd like to deal with those things. So, Ethics Queensland. What you should see now is the website for the Queensland Law Society Ethics Centre. You'll see some excellent material in relation to Introduction to Legal Ethics, the Australian Solicitors Conduct Rule, various ethics resources, practice resources, and up-to-date information and news. A very valuable resource, and I'd encourage you to look at that. Do look at the guidance statements and the ethical rulings as well. Now, within the context of that page, you have what's called applied legal ethics, which should be of particular interest to you, particularly coming into an examination session. So I'm going to stop the share and now take you to the applied page, which you should see now. So Introduction to Applied Legal Ethics. And you'll see that it provides some commentary in relation to where lawyers' ethics are sourced. I've referred a number of times to the ASCR, the Australian Solicitors Conduct Rules. You do need to consider the Legal Profession Act 2007, and that piece of legislation applies equally to solicitors and barristers, you need to consider the intrinsic controls and the common law. Now, there's reference there to the Legal Services Commission Dispute or Discipline Register. So do have a look for the website to the Legal Services Commissioner for Queensland, which is Mr. Paul Clawson. The material that you have on this website also provides some excellent resources and updates and further information. Now, are there any questions that arise from your independent research in relation to ethical issues at this stage? All good? All right. I'll just show you the website for the Legal Services Commissioner. And if you're watching this, if you've got access to a computer at the moment, you might wish to find this independently. So the Legal Services Commissioner has some information in relation to publication, complaints, discipline, various fact sheets, and all of that should assist you considerably in terms of your independent research. Then when you're looking at the Queensland Ethics Centre, do look at the guidance statements. I mentioned those earlier. For example, guidance statement number 12, I'm not showing you this on the screen, but you can look at this independently, deals with issues about conflict of interest in criminal and crime and corruption commission proceedings. So there's very specialised information. And invariably, if someone is prosecuted as a result of an alleged breach of ethical rules, then where appropriate, the Legal Services Commissioner or QCAT on appeal would consider the guidance statements that are provided by the Queensland Law Society, or if you like, the Barristers' Rules and Association as well. So hopefully you have good access to that material. Now, in the lead up to tonight, I think I provided you with some summary of what I believe to be the most important rules. Did I do that? So for solicitors, for the Australian Solicitors Conduct Rules, the fundamental duties of solicitors contained in rules 3, 4, 5, and 6. When we look at those rules, the first one that really stands out is Rule 3, and that is that a solicitor's duty to the court in the administration of justice is paramount and prevails to the extent of inconsistency with any other duty. So that's the guiding principle, and we have similar situations that apply for barristers. Rule 4 deals with other ethical issues and duties, and that is fundamentally, once we leave aside the paramount duty to the courts and the administration of justice, the next duty is in relation to the interests of the client and to represent the client, but at the same time being honest and courteous in dealings in the course of legal practice. So Rule 3, Rule 4, critically important. Beyond that, there are issues of how you deal with clients. So look at Rules 7 through to 16. And importantly, look at Rule number 8.1, which says that the solicitor's obligation is to follow the client's lawful, proper, and competent instructions. So breaking that down, if a client asks you to do something that is unlawful, then you should refuse to act, and indeed you then impliedly breach the obligations because you're acting in a way that is inconsistent with the administration of justice. The instructions need to be proper. So what that means is that you don't blindly follow every instruction that is provided to you. If it's not a proper instruction, then you're duty bound to say, no, I'm not doing that. So it's got to be a proper instruction. And finally, it has to be a competent instruction. Now, that can be a grey area, but can anyone tell me where you would look to determine the definition of what we might mean by competency which is aligned to capacity. What legislation deals with the issue of a person's capacity to make decisions, which then goes to their competence? Anyone got that? If you're really struggling, what website would you look at to try and get you some idea of the legislation that might be relevant to that issue? So I'm asking now the dual question, what is the Act? And if you don't know the Act, what's the website that you might use to find the relevant Act? Some trick questions here. LawLex, thank you, Gareth. That's the answer to the second question that I was looking for. LawLex says Mackenzie as well. And the answer to the first question is the Guardianship and Administration Act for Queensland. So look at that in terms of the definition of capacity. So I'm working on the basis there that someone who is not capable of making decisions would not then be in a position to provide competent instructions. Now, when you're looking at the Australian Solicitors Conduct Rules, look at Rules 17 to 29 inclusive to deal with the issues of advocacy and litigation. You see, you have specific responsibilities as a solicitor to the court process, opponents, to witnesses, and there are special rules in relation to cross-examination and special rules for prosecutors. So, for example, Rule 21.2 provides that a solicitor must take care to ensure that decisions by the solicitor to make allegations or suggestions under privilege against any person are reasonably justified and are appropriate for the robust advancement of the client's case and not intended or done primarily to harass or embarrass a person. When you're reading these rules, do so within the context of something that might be realistic and try to think when you might be called upon to consider and work within these legal constraints. Now, again, I'm dealing with the Australian Solicitors Conduct Rules. After all, at least 90% of the profession in Queensland are solicitors, as opposed to less than 10%, I think, as barristers. But the barristers' rules have similar rules, and you must consider those as well, certainly from an examination perspective. So when you're looking at the barristers' rule, 2011, you can find that on the Bar Association of Queensland website, and I think on Moodle as well. The important rules, I think, are rules to do with advocacy, rules 12 to 14 inclusive, duty to the court rules, which are rules 25 to 36, duty to the client rules, which are rules 37 to 40, and the responsible use of court process and privilege rules 59 to 67. Now look beyond that, but they're, I think, the key ones. And when you're reading this material, it might become apparent to you from an ethical perspective that there is a conflict likely between your professional ethics and your personal ethics and beliefs. Essentially, the lawyer's job is to put aside their own personal bias, belief systems, and work within the law to advance the client's cause, provided, of course, that they're mindful of the paramount duty to the court and administration of justice. So, according to the traditional view of that dichotomy, a lawyer must act in the best interest of the client, even if doing so is inconsistent with the lawyer's own personal values. Now, the alternate approach is that responsible lawyering emphasises the role as an officer of court. My view is that you've got this holistic view where you must ultimately follow what it is that your client wants rather than what you think. So be very, very careful when it comes to providing your judgment through your personal views or indeed perhaps biases when it comes to advising clients. In other words, deal with the client's problems in their best interests rather than necessarily your best interests or your preconception or personal views. Any questions so far? All right, let's have a little quiz. Now, you've taken all that in, you've got access to the material, and let's just do a what-if situation. Think about how you might deal with a situation where you're put on the spot as a first-year solicitor. Think about what you might say in giving immediate advice to a person in a dispute situation. An ethical issue might arise, and ask yourself how you might deal with that issue. I mean, to take any, and I won't give you any specific examples, but what I want you to do is, as you're reading through the case law, put yourself in this situation and ask yourself, when you read the factual situation, how would I deal with that? And then try and read on with the case and look at how it was ultimately determined and see if what you believe you would do in those circumstances aligns with the ultimate decision. Any questions? All good? Okay. So let's move on to a slightly different area, and that is the area of litigation. And again, I'm just trying to put it all together. So, a different topic altogether now. So we're talking about the first steps in civil litigation. Someone comes to you and says, I want you to pursue a debt. Putting together the legal side of things and the practical side of things and the ethical side of things, what are some of the first questions that come to your mind that you should ask the client in relation to the debt that they're pursuing? Really broad at the start. Tanya says the amount of the debt, yes. The amount of the debt, the relationship with the debtor, very good. How much is the debt versus the cost to secure the debt? Yes, all good questions. Thank you very much. Keep them coming. Someone says, I want you to pursue a debt. Before we start doing it, how did the debt arise, says Peter. Yes. What other questions are there? Tuna says, how much is the debt? Yep. All right, so we've got a lot more. How long has it been outstanding? Very good, Tanya. When did the debt come about? Gareth says, same thing. Who are the parties, says Peter. We'll return to some of these. Come on, there's more questions than this. If you're watching this as a recorded session, please get your thinking caps on. Also remember, every question that you answer in relation to law, you must consider the ethical issues that might arise also. Oh, I like this answer from Gareth. What result do you want? I like that. That's good. Anything else, or are we running out of the location of the parties? Very good, Rachel. Is this the first time you discuss the debt with a lawyer? Yes, Tuna. Yep. That may be relevant depending on the nature of the debt. All right. We're doing this. What steps have you taken already, says Tanya. Now, we're looking at this question within the context of you being a first-year lawyer in a law firm, let's say. One of the common scenarios that I ask in a question. From an ethical perspective, are you allowed to sue an existing client of the firm? Would that make you feel uncomfortable if you knew that the client was wanting you to pursue someone who's already a client of the firm? Conflict of interest, says Tuna. Conflict of interest, says Gareth. Tanya says questionable. Yes, you've got to explore that. So how would you know? You're first year. You've only just arrived in the firm. Unless the client agrees, says Tuna. How would you know? What would you do to find out? What are some of the preliminary questions you'd need to ask yourself? Check the client records. Thank you, Tanya. So one of the very first things that you must do to ensure that you don't find yourself in an ethical issue is to undertake a conflict check. I thought that might have been one of the very first things that people ask for. Ask time to look at the matter, says Tuna. Yes. So you've got to conduct a conflict check. You've got to make sure that there's no breach of your ethical obligations through conflict of interest. All right, other issues that might arise from what seems to be a very simple question is, we've talked about when was the debt incurred? Why is that relevant? When did the debt come about? Was a question posed by Gareth. Does it matter? The legislation may have changed, yes. What else? Look at trading terms, says Tanya, yes. So look at the documentation that goes with it. What about, has anyone heard of Gareth's got it, outside the statute of limitations. So it may be that the debt is already statute barred, in which case you might be asking questions then about, not so much about the debt, but how it came to be that this debt was statute barred, which comes back to one of Tuna's ideas. Is this the first time you've discussed this debt with a lawyer? Maybe there's an opportunity to sue another lawyer. Lawyers do that, you know. It's just part of the territory. All right, so when did the debt occur? Now, someone said, where was the location? Rachel said the location. Why is that relevant? Why is that a good question to ask in relation to a debt? Jurisdiction. It might be a jurisdictional issue, says Gareth, Tanya and Tuna. Absolutely right. So if the debt is one that was created in New Zealand, then perhaps it's best you don't issue proceedings in the district court in Rockhampton. Do you understand what I mean? So there are jurisdictional issues that come to mind as well. Someone mentioned the document, the paperwork. Is there a contract? What is the documentary trail of evidence? So these are all important questions, and there are many more that you must consider. What's the usual way to start by pursuing a debt? You normally just issue the proceedings. Letter of demand. Thank you, Tanya. Thank you, Peter. Why would you send a letter of demand? Isn't that just incurring extra costs unnecessarily? Well, if you go to court and you're successful, give them a chance to pay or explain, says Tanya. Exactly. And that's important because if you immediately sue, Peter says, may settle before any further action is necessary. That's right. If you just sue and that's the first they know about your involvement and they pay straight away, they might say, well, if you'd sent a letter of demand, you wouldn't have had to sue and incurred these costs. And the court may agree with that as well. So you may not be able to get your costs. So you do need to consider a whole range of things, even in response to that very simple question of, can you pursue this debt for me? So what I'm getting at is that you need to create, if you like, some checklists or try to source some checklists relevant to these sorts of issues and do so within your ethical guidelines. Part of this comes down to the issue of self-management and your ability to be in control of the process. So this is my segue to self-management skills. So within the context of being ethical, you've got to look after yourself as well and your mental health and well-being. And you might recall in week 1, I said, please adopt a process of looking at the end result that you wish to achieve, work back from that. Tanya says, checklists are great when you're busy. Absolutely right. And I would recommend that you create many of your own checklists and source information from a number of areas and put it into a form that works for you. It's pretty rare that there's a checklist which is, if you like, mass-produced that I've adopted. I've always taken information from various sources to create my own checklists, if you like, and I'd recommend that to you as well. Now, one of the reasons you do that is that you will be under pressure, and by creating a checklist, you're better preparing. So better preparation means better results, which means less stress, better mental health, better well-being. And just to put a downer on it, and I think I mentioned this in week 1 also, the rates of people that are adversely affected from a mental health perspective practicing in law is very high. The former version of the New Lawyer put out some stats on this, and I don't know if it's in the current version. I haven't checked this, but depression, I'm told, according to the records, affects about 1 in 3 solicitors and about 1 in 5 barristers, which is, I don't know, about 4 times the rate of the general population. So you've got to make sure that you are in control and prepared and get your body and your mind in good shape. We were never taught this at law school, I can guarantee that to you, but it's really important. Rachel says self-care is really important, and it is. So, maintaining a healthy lifestyle, being aware of the substances and don't abuse substances is really important in terms of strategies. Okay, so when you're dealing with masses of information, and now I'm talking about strategies, has anyone found some strategies that help to deal with this massive information from a number of sources? Because I'm sure you've been surprised at the amount of reading that you need to undertake in order to study law. Has anyone got any hints or techniques that they'd like to share about things that have worked well for them in terms of dealing with a mass of information? And you says important to reach out to other staff members. Yep. All right, so you've got a full textbook to read. What's your approach? What do you do? There's no right or wrong answer here. Very old-fashioned way is to use the old highlighter. Others to look for key information. Don't overload yourself. Yes, that's important as well. Another is that I use is to use my voice to record notes and checklists and create summaries. If you look at that Tier 3, Level 3 preparation for exams and take-home papers video, I suggest that you try and create model answers, at least to some degree, ready for the examination. And that's a good way of getting yourself ready and prepared. So unfortunately, you need to find out some techniques that work for you. When you go through your legal studies and indeed your career, you will find that you don't, or you're appearing in front of a judge, things don't always work out the way you'd hope. And in fact, sometimes things can go badly. And the feedback that you may receive, either from a unit coordinator or from an employer, a client, a judge, may not always be positive. So be prepared for that, take it in your stride, and remember the big picture here. So try to take any comment that is not positive, as a learning experience, and say, that's great, I've overcome that. And every time you find yourself challenged in the study of law or the practice of law, and you overcome it, then think to yourself, that's now a hurdle that I've been able to manage. Others may be dropping off as you proceed, and take pride in the fact that you're marching forward and you're remembering this big picture. So a lot of it is to do with resilience, and try to think of things in the long term, learn how to harness the stress and embrace it, oh, you'll be under stress. If you're practicing anywhere in relation to law, and I'm not talking just about law firms or being in barristers' chambers, but in anything to do with government, private industry, or even if you don't practice in law, but you're using legal concepts elsewhere, then you will be under stress. So a couple of things that you might want to consider: adopt a do it now attitude. So another is to prioritize. Now, they may be in conflict with each other, but sometimes knocking over a few jobs gets you in that mental state, gets you in that stride to go and tackle the big ones. Other people like to adopt the approach of, no, let's get the big one done first and then we'll deal with the little ones. But whatever it is, you need to conscientiously prioritize. Now, I'm a bit of exception to that because I don't mind actually jumping between one to the other, and I find that is a way that works for me. But most people probably need to concentrate 100% on what they're doing in the task ahead of them. When I first started in law, what I did was, you have a bundle of things, and I remember on one occasion, my first week, I had a list of 30 things on my sheet, and I came in the next morning, and one of the partners who'd given me some work looked and saw that the task that I'd allocated as number 23 had a scribble next to it. When are you going to get to number 23? Can you make it number 3 instead? Or something to that effect was the note that was given by the partner who'd given me the task. But whatever it is, make sure you prioritize, and where you can, knock jobs over. So that is that do it now type attitude as well. I know I'm talking about a lot of general things tonight, but it's all part of self-management, resilience, and within the context of legal ethics. All right, so we're getting to the stage where that's all for this evening. I know it's a short evening, but are there other issues that you want to discuss? And next week, we'll largely be doing a statement, just an overview statement. Are there any issues that you want to discuss tonight? I know it's short. That might be a good thing, maybe a bad thing. Any questions, comments? All right, so next week, we'll be looking at preparing for the examination that I'll release. We'll be talking about general overview of what we've covered in this unit, and I certainly invite you to think about questions that you'd like to ask during this week and elsewhere. As for me, I've got to get some examination or some assessment feedback to you promptly. I appreciate that, and I will do that. All right, any questions before we knock over? We adjourn for this evening? All good? All right. Look after yourselves. You're going to be under pressure for the next couple of weeks, but I'm sure that you can cope with it. All right. All the best. That's it for this evening, and we'll see you next week. Bye then.